Honorable Court of Appeals of Tennessee is now in session.
Thank you, Ms. Lindsay, and on behalf of Judges Bennett and McBrayer, we welcome counsel to this oral argument, which we are live streaming to maintain our open court requirement. We will conduct the hearing in the same manner as if we were all together in the courtroom. Each of you has 15 minutes, and the appellant has reserved some of that for rebuttal. Unless there are any announcements, I'm asking Ms. Lindsay to call the case.
Eltricia Laree Cook versus Gary Lynn Fuqua et al.
Thank you, and the appellant has the floor.
May it please the court. Al Stolte on behalf of the appellant plaintiff Eltricia Cook. This appeal is the result of a grant of summary judgment where there are disputed facts and inferences that could be drawn from those facts. Back on October 21st of 2018, the appellant was injured by an animal that was in the control and possession of James Allen Tipton. Mr. Fuqua was the owner of the property and had notice and knowledge of Mr. Tipton's animals and their ability and his allowing them to run at large.
I thought they were kept in a fenced-in area.
Yes, and from time to time they would get out or they would be let out and roam at large.
Did Mr. Fuqua know they were out?
Yes.
He knew they were out at this instance.
Not at this instance, but on prior instances.
Okay, then if he didn't know that they were out, how can he still be liable?
In the same manner that a landlord who has knowledge of his tenant's vicious dog and the propensities could be liable in the same manner, just because he is not physically present or has what I guess would be termed by the defendant actual control or actual possession, which is not defined in the law. It doesn't matter if he's not physically on the property, just like an absentee landlord. And it doesn't matter if he's not the owner of the dog. If he knows that his tenant has a vicious dog that is allowed to run at large and can cause injury or damage, he can be held in the same manner as an agent principal.
So he knew that his stepson would let and permitted his stepson to let the animals out from time to time?
Yes, that's the testimony from the plaintiff. That's in her answers to.
He didn't sanction his stepson in any way when these came out. He was okay with them running around.
He may not have sanctioned them, but he allowed it.
I don't see much difference in that.
Well, he could have thrown his stepson off the property. He could have gotten the sheriff to come out and take him away. He could have done any number of things to prevent this course of conduct from continuing.
Did he tell the stepson to not let them out?
I don't know.
Okay. And there were two, right?
Yes.
Two pot-bellied pigs, Baxter
Correct.
and another one.
Yes.
Okay. Thank you.
And you're saying pot-bellied pigs are like a vicious dog?
They can cause damage. It could be like livestock, like cows or horses, if they were allowed to run loose. They could cause damage to property and to persons, depending on the circumstances.
Does the record tell us about the size and weight of these pot-bellied pigs?
Very briefly, I believe. Around the order of 100, I believe. I'd have to go back and look through the testimony. 100 pounds, 150 pounds, something of that nature. May I continue? I'm sorry.
Yes.
Oh, okay, thank you. The defendant presents the arguments, and I've already covered a little bit of it, of actual control or actual possession of the property. And I've already addressed that issue. The second issue is the statute 2934-208, specifically subsection A2. Prior to this council, before the substitution of counsel was put in, the plaintiff had answered a request for admission that Mr. Fuqua didn't give her implied or express permission to enter the property, so that she was a trespasser. However, she was returning personal property to its point of origin. And based
Is that
on
an
the test,
exception in the statute?
no,
Okay.
based on the deposition, the sworn testimony of Mr. Fuqua, and that's page 88, line 12 to page 90, line 17, she did have implied permission from him. And the relevant request for admission states specifically Friday, October 12th, 2018, that he didn't give her permission on that day. But there's no other, you can read the relevant part of his deposition, that if the hogs were loose, she should have done what anybody else would have done and got a stick and herded them back to the property, which is exactly what she did. Further, the statute specifically mentions under the definition lawful occupants, in addition to Mr. Fuqua. And there's no dispute on this. His wife, Lisa Diane Fuqua, and the co-defendant, James Allen Tipton, were lawful occupants of that property. The record does not address any instance of where they denied, implied, or expressed permission to be on the property. In fact, Mr. Tipton was on the property at the time this incident occurred and did not tell her to leave. Again, based on the facts that we have in this is an agent principle. The acts of the agent can be imputed to the principal based on the prior knowledge and no ability or no conduct to prevent Mr. Tipton from continuing this course of conduct, leaving the animals out. I mean, not only did they injure Miss Cook, but they also destroyed a front door on her father's house prior to her injury. So basically, they knew about what was going on and failed to stop it. And in this vein, these facts are disputed. The inferences that come from these facts should be resolved in favor of the plaintiff. And I can get into more detail on my rebuttal, but unless you have some questions, I'll stop now.
All right. Thank you, Mr. Stolte. We'll hear from you on rebuttal. Mr. McClellan.
Thank you, Your Honor. I'm Art McClellan of the Sumter County Bar, and I'm representing Gary Fuqua, the appellant in this matter. I disagree with Mr. Stolte regarding disputed facts. The material facts necessary to resolve this case are absolutely, totally undisputed. Approximately a month prior to the accident, unfortunately, my client was charged with domestic assault. He was taken to the Macon County Jail When he was released from the jail, he went to live in Hendersonville, Tennessee, which is approximately 50 miles from the scene of this accident. For the month prior to this accident, he lived continuously with his sister in Hendersonville, Tennessee. That fact is acknowledged and is not in dispute. The two potbelly pigs involved, and there's nothing in the record as to their size or weight, were owned clearly and undisputed by James Allen Tipton. It's undisputed that on the day of Miss Cook's accident, James Allen Tipton intentionally opened the gate and let the two potbelly pigs out to run for exercise. And that testimony is undisputed, and that testimony is admitted in a request for admissions. My client did not give Mrs. Cook either express or implied permission to be on the property on the date in question. That's admitted in request for admissions 10, and it's admitted by Mrs. Cook in her deposition. Unfortunately, the record that had her deposition was not forwarded to the court, so I attached the deposition as an appendix to my brief. If you look at appendix page 29, page 16 of the deposition, beginning at line 3, she testified that nobody invited her onto the property. So there's no question about an invitation to be on the property. Not only did my client not allow it, and as set forth in request for permission 10, she testified to that fact in her discovery deposition.
Was it a common practice for the stepson to let the pigs run? Was that something Mr. Fuqua permitted?
Actually, that is not clear, Judge. I think it could be inferred that he was aware that from time to time that Mr. Tipton allowed the two pigs out to get exercise. I don't think there's any direct testimony on that. In fact, I know there's not. I will say further that in Mr. Fuqua's testimony in his deposition, he made it crystal clear that he didn't even want the pigs on his property and that they were being allowed to be there because of the insistence of Mr. Fuqua's wife. And he tended to be submissive to her desires. And that's what the sworn testimony is. He didn't want the pigs. He didn't want them there at all, but he did nothing definitively to have them removed or to prevent the stepson who lived adjacent. He did not live on the property. He lived adjacent in a travel trailer from engaging in the activities you asked about. I think it's also.
But the pen where the pigs were kept, that was on Fuqua property.
Yes, sir. Absolutely. There's no question that the pigs were being maintained on Mr. Fuqua's property in a pen with a properly locked gate. If you look at the complaint, they allege that the pigs got out because of negligence in the pen. The facts didn't bear that out. It's undisputed that Tipton let the pigs out.
I'm worried about, the idea of treating Miss Cook here as a trespasser when what she was doing, it seems to me, is what you would want a neighbor to do is make sure your pigs get back home. And you want to call that trespassing?
Absolutely. If you look at the definition in the statute, and if you look at the Supreme Court case that defines the duty, the 61 case of Jack Bass versus Parker, there's no question she's a trespasser. And there's no question.
So I guess by that theory, it'd be better if Miss Cook had just let the pigs out into the road and just washed her hand at them.
Well, she could have chased them over in the yard if she liked, but she didn't have any business. There were two people out in the front yard when she chased them into the yard. One of them was Tipton's girlfriend. The other male that was in the front yard, we don't know who he was. But what we do know, based on Miss Cook's own testimony, and again, I invite you to my appendix, you'll find that all she had to do is chase them into the yard if she wanted to do that. and tell the two people standing in the front yard of Mr. Fuqua's property, you need to get the pigs in. And that's simply not what occurred. She took it on herself not only to chase them into the Fuqua property, then she went to the front door and started banging on the front door. And that's when Baxter came and jumped up on her and caused the injury. Yeah, it would have been better for her to stay off the property. She wouldn't have gotten hurt.
You could have made a phone call.
She could have made a phone call. She could have called the deputy sheriff to have him come out there to look at the damage to the so-called front door. Today's the first day I've heard anything about damage to the front door. It's not in the record. There's any number of things she could have done within the confines of what was perceived by the Supreme Court in the Bass versus Parker case and is codified by the legislature in TCA 2934-208. By the definition in the statute, there's no question, absolutely no question, that Mrs. Cook was trespassing. And there's no question that if you look at the complaint, which was never amended, there are no allegations that Mr. Fuqua engaged in gross negligence, intentional acts, wanton disregard, or any things that could be construed as a duty beyond ordinary care.
There's no doubt, is there, that she never got permission to enter the property from anybody because she hadn't talked to anybody before going up on the property and on the porch.
That's correct, Judge. And in fact, the record is void of her having ever talked to anybody, and even in previous days, let alone the date of the accident, in terms of getting permission to come on the property. The record is
So what do you think about their argument that, well, perhaps, it could be the other lawful occupants of the real property gave her permission?
Well, the problem is that wasn't pled. It's beyond the scope of what was argued before the trial court. And there's no factual evidence to support that. That's a theory that Mr. Stolte developed on appeal.
Mr. McFarland, the irony here is that the plaintiff is being treated as a trespasser when all she was trying to do was to bring the bacon home.
I don't disagree with that, Judge, but unfortunately, the law is clear that she was a trespasser irrespective of her intent. A lot of trespassers do things for good and constructive purposes, but it doesn't change their status upon the property if they fall within the definition of the statute.
Why did she go over to the property? Did she testify that she went over to just tell him that they were running loose, or did she go over to yell at him about the being on her property, or what? Why did she go over there?
Her testimony was that she went to inform him he needed to get them up. That was her testimony, Judge. As to what her actual intent was, I don't know. There was some yelling back and forth between her and Mr. Tipton after the accident occurred. I know that. But, I might be yelling too if I'd been knocked over by a pig and got hurt. So
the only one pig attacked her, right?
I wouldn't even
Baxter?
say attacked her. My perception of what occurred, Judge, is Baxter jumped up on her wanting to be petted. He was a friendly pig, but he loved interaction with human beings and he wanted to be petted. But yes, he jumped up on her. There's no ifs, ands, or buts about that. That occurred.
Only one pig did that, though. The other one didn't, right?
That is correct. Only Baxter did it.
Only Baxter. What was the other pig's name?
I don't know, because he was it was a she, as a matter of fact. Baxter was the little male and the other pig was a female. And I didn't ever know her name because she wasn't an actor in the case.
Okay.
In what little time I have left, and I do this with great reservation, but in this case, I can't see that there's any judicial issue for resolution by this court. The material facts that are necessary to resolve the underlying appeal are undisputed. In fact, they're admitted in requests for admissions. The law has been in effect well in excess of 50 years when you consider the 61 Supreme Court case. So there's no effort to change the law. I've raised the issue of whether this matter is a frivolous appeal. I've been involved in a lot of appeals over the past 45 plus years. And in looking at this case, I can't see what the issue is before this honorable court. That is the definition of a frivolous appeal as far as I'm concerned. And I think the court should approach frivolous appeals sparingly, but my client shouldn't bear the burden of a cost associated with the appellate process when there are no material facts in dispute, when there's being no effort to alter or amend or extend the law as it is in effect in the state of Tennessee, particularly when there's no question about the legal definition of a trespasser, and there's no question about the fact that the complaint does not allege any of the duties required in order for a trespasser to recover. Mr. Stolte did not respond to that. He did not file a response. I don't know what his position is. I can simply say to the court, you hear these a whole lot more than I do. I will say this, I clerked for the Supreme Court out of law school. I've seen a lot of appeals, not only as a law clerk, but as a practicing attorney. And if this one doesn't fit the definition of a frivolous appeal, I simply don't know what does. I appreciate your time. I appreciate your questions. If you have any additional questions to me, I'd be happy to try to answer them in the next 2 minutes.
Thank you, Mr. McClellan, and we'll now hear from Mr. Stolte.
Thank you. With regard to the trespassing, that would, under that strict definition, the mailman, the UPS delivery driver, the FedEx driver, the utility reader, they all would be trespassers. There's no express or implied permission for them to be on the property at any time. Maybe the person's expecting a delivery, or expecting their meter to be read, but they've never been given express or implied permission. Anybody, a solicitor, anyone is a trespasser. Be that as it may, I want to make clear that these people knew each other. And if we look at the trial record, page 104, that specifically lists, it says, he would sometimes let them out, and other times they would get out through the yard and the fence. They went and visited. Gary Lynn Fuqua was a frequent guest at my father's residence, which is right next to hers. And both her father and Mr. Fuqua knew the customs and habits of these hogs. And also, there were affidavits attached to the response to the motion for summary judgment, which puts these facts in dispute. To emphasize the law in this area as to address the frivolous part, as a general rule, summary judgment is not appropriate in a negligence action. It's only appropriate when the inferences which may be drawn from the facts are so certain that all reasonable persons must agree. If the facts are uncontroverted, summary judgment is inappropriate if reasonable minds could differ to the inferences to be drawn therefrom. The stuff that I just stated is also in the appendix about how they knew each other and how they would go back and forth to each other's properties and talk. You can read Mr. Fuqua's deposition, which is part of the record, and he testified that she had been over on his property plenty of times. The court The trial court should take the strongest legitimate view of the evidence in favor of the non-moving party. And that if there's any dispute as to any material fact or any doubt as to the inferences or conclusions or inferences to be drawn from that fact, the motion should have been denied. And that's what I have to say.
All right, thank you, Mr. Stolte and Mr. McClellan, for your arguments. We will take this matter under advisement. Ms. Lindsay, you can close court, or recess, I should say.
This Honorable Court of Appeals is in recess until 1 p.m.
Thank you, and counsel, you are free to exit the meeting.
Thank you.